Hi everyone. I'm Beth Rebay, the host of the Civics Project and the Director of Repair, which sponsors the Civics Project. And I'm delighted to welcome you to our episode on same-sex marriage. Before we begin, I'd like to share a brief land acknowledgement. Repair acknowledges the Gabrielina Tongva peoples as the traditional land caretakers of Tobangar, the Los Angeles Basin and South Channel Islands. And we are grateful to have the opportunity to work for the Taraha Tome, the indigenous peoples in this place. We pay our respects to Hanuk Vitam, the ancestors, Ahihiram, elders, and Eohinkem, our relatives and relations, past, present, and emerging. So, as noted, this episode focuses on the subject of same-sex marriage in the United States. And I want to start by acknowledging that the ways in which folks over in areas like gender and women's studies or LGBTQ studies or activist and feminist and LGBTQ social movements think about sex and gender is different than the ways in which legislatures and courts typically do. So we're going to use the legal language, which refers to marriage as the same sex. And in doing so, my intention is not to ignore the complexity of gender identity or gender nonconformity, but we'll present the terms in the way that the law does, and then we'll have room to think critically about them. So with that said, I want to just dive into a relatively just over 50-year history lesson. So try to think about the evolution of the legal concept of same-sex marriage. And I want to basically start in 1969. So we could easily go back into either the history of marriage, and there's a lot about the gender politics of marriage that is meaningful to tease out, or the politics of sexual orientation and sexual identity in US legal history. But in the interests of some brevity and keeping our discussion focused, we'll begin in 1969 with the Stonewall Uprising, just to acknowledge that this event and period particularly marked the entry of, at the time as it was framed, lesbian and gay communities, later to become LGBTQ plus, but to start to conceive of the idea of gay people, and then lesbian and gay people later, bisexual, transgender, queer folks, having civil rights. And again, we want to understand 1969 is right in the thick, the pinnacle of the civil rights era around both race and issues around indigenous sovereignty. So in 1971, the Supreme Court eventually heard the case Baker v. Nelson. It's important to understand, though, that the case began in 1970. So again, it was right after the Stonewall Uprising, and LGBTQ folks were starting to think differently about prospects for legal recognition and rights. Richard Baker and James McConnell were a gay male couple who applied for a Minnesota marriage license in 1970. When the state denied them, they sued, they went to court, and were denied in the trial court. And in 1971, the Supreme Court ruled for the state of Minnesota and against Baker and McConnell, and effectively set a precedent right after. In 1972, Baker appealed again, and the Supreme Court said there's a want of a substantial federal question. What they meant is there's nothing for us to even consider here. The idea of same-sex marriage has no foundation in any area of federal law, and therefore the Supreme Court has nothing to decide. So they were basically saying there is nothing at all in the Constitution or any other area of federal law which would support gay people attempting to sue the state for the right to marry. Because they had said this, because they had said basically there's a want of a substantial federal question in the 1971, this basically precluded state courts from even considering the question, right? If the Supreme Court was saying there is nothing in federal law or the Constitution that would enable this possibility, every lower federal court had to follow suit, had to follow them. And so that meant until the legislation changed, until the law changed through the legislatures, this is a question that could only be heard either again by the Supreme Court, which they didn't opt to do for quite some time, or through the state courts. And so that's what happened, was individual states then had to figure out, is there any basis in law which the state might support to enable same-sex marriage? In 1973, shortly after the Baker versus Nelson decision, Maryland weighed in on this question by becoming the first state to define marriage as a union between a man and a woman. So they were recognizing that the fact that the Stonewall Uprising had happened, that the statute, the social and legal status of LGBTQ people in general and same-sex marriage in particular was potentially an area of contention. And so they went out of their way to say, not here. In Maryland, marriage is only recognized between heterosexual couples. So throughout the rest of the 70s, we saw a number of states follow suit, first Virginia in 75, then Florida, California, and Wyoming all passed basically anti-same-sex marriage legislation or amendments to existing legislation in 1977. And so after that, there was sort of a long period in which there was a slow build of social movement activity, but very, very little advancement or growth in this area of law. Basically, states remained kind of a stronghold against the possibility of anything other than heterosexual marriage. The first major legal breakthrough after that came in 1989, or at least there were some small ones, but this is the first one I'm going to really take note of because it had I would say, national impact. And that was that in 1989, the San Francisco Municipal Board of Supervisors allowed same-sex couples to register for domestic partnership. So they were basically saying, okay, we're not redefining marriage. We understand we don't have the ability to do that fully, but we're going to start to create workarounds for LGBTQ people. So San Francisco only, then followed in the early 1990s by the District of Columbia. So you're starting to see just municipalities test the boundaries of the law, and even then they're not really in a position to redefine the meaning of marriage. San Francisco, for instance, couldn't overcome the California state law, which had been in place since 1977, saying marriage is only between a woman and a man. But what they could do was, again, create domestic partnership as a legal category, which at least in that county would have an acknowledged set of rights associated with it that would partially parallel what legally married couples could get. So again, DC followed them. And then in 1993, there was a breakthrough in Hawaii. The Hawaii Supreme Court, in the case Bear versus Lewin, found that a state level same-sex marriage ban might be in violation of Hawaii's constitution, specifically its equivalent of the US Constitution's Equal Protection Clause. So the non-discrimination language that was built into the Hawaii state constitution, its court found that if the state was trying to uphold a same-sex marriage ban, that it could violate the state constitution. The Hawaii government continued to advocate for the ban. So they spent several years after that in the courts arguing that they had a compelling state interest in justifying the ban. And for those non-lawyers in the bunch, a compelling state interest in constitutional legal doctrine basically is a way to overcome the issue of discrimination. So generally speaking, our equal protection clauses, both at the federal and state level, say that you should not discriminate. And if you do need to, then you need to do it as little as possible. And there needs to be a very important reason for the state to do it. So since the Hawaii Supreme Court was saying, oh, we're going to accept the possibility that this is discrimination, the state of Hawaii then began to argue, well, then we have a compelling reason why we need to discriminate. So they again spent several more years in Hawaii fighting that out in the courts. In the meantime, in 1996, Congress passed the Defense of Marriage Act, DOMA, which was signed by then President Bill Clinton. Now, DOMA is tricky. It did a number of things. It didn't explicitly ban same-sex marriage. So it still left room for states to legalize it for their states. But what it did do was basically indicate that any federal benefits associated with being a married couple would not be available to same-sex marriages. So it's saying states, if you're moving in this direction, fine, but the federal government won't support it. That means if your state allows you to get a same-sex marriage, you can't file joint federal income taxes, right? So the IRS won't recognize who's married. You can't sponsor your spouse for immigration. So if you marry outside of the United States, you're not going to be recognized as a spouse for the purposes of sponsoring your husband or wife or partner to enter the country. If your spouse dies, you can't receive spousal Social Security. And in addition, DOMA did something else, which is that it basically said that states do not have to recognize same-sex marriages performed in other states. So, generally speaking, for instance, if you get married in California, and your partner move to New York, you don't have to remarry in order to be recognized as a married couple. New York accepts California's marriage license through a legal concept we call full faith and credit, which basically means that things like marriages and divorces in one state or adoptions travel, other states will recognize them, even if they have different requirements. So DOMA created an exception and basically said, even if one individual state recognizes a same-sex couple as married in their own state, that doesn't travel. No other state has to honor that marriage. And Hawaii in 1998 took a swing harder against same-sex marriages through a voter proposition on their state ballot in which Hawaii voters amended their state constitution to ban same-sex marriage. So, if you remember just a moment ago, I was saying that Hawaii's Supreme Court and its state government were, litigating out this question of whether it would violate the Equal Protection Clause of the Constitution to have a same-sex marriage ban. And the voters basically settled that by saying, well, we will just amend the Constitution so it doesn't. So in 1998, Hawaii became closed to same-sex marriage and has continued to be something that was hotly advocated for and debated, held up by its opponents as evidence of the sort of spiritual deterioration of the United States, and by its advocates as an essential part of the civil rights project in the United States. The next major progress was in 2003 when the state of Vermont legalized civil unions for the first time. And again, we want to distinguish between having state or federal having rather federal marriage rights and being able to have a civil union, which the state of Vermont was basically saying like, okay, we will recognize this as, a legally cognizable form of marriage with some limitations and definitions which were built into the law. But it practically meant that people could go and get married at the civil level if it was available in the state of Vermont. So in 2003, we saw the first kind of major win in a state Supreme Court since Hawaii, and that was in Massachusetts. And they went farther than Hawaii did. What the Hawaii Supreme Court had previously said was it might violate the Equal Protection Clause to ban same-sex marriages. Massachusetts went farther. So again, this is 2003, and the case was, when the case was decided, and the case in question was Goodridge versus Department of Public Health. And it was basically the plaintiff, Goodridge, suing the state, saying, I want a marriage license. The Massachusetts Supreme Court sided with Goodridge, and on May 17th of 2004, the state of Massachusetts began to issue marriage license to same-sex couples. Now, we want to remember at this point that DOMA, the Defense of Marriage Act, is still in effect. So this didn't mean that you had marriage rights that extended either to any federal benefits or resources or outside of the state of Massachusetts, but it was still a significant breakthrough. In 2003, though the case was not about marriage, the Supreme Court decided Lawrence versus Texas, which overturned a Texas sodomy law, which criminalized same-sex sexual activity. So they found that in Lawrence versus Texas, the state of Texas was violating people's basically sexual privacy by trying to criminalize sodomy. This was important generally for LGBTQ rights, but also for the landscape for same-sex marriage, because it knocked out one of the major arguments against same-sex marriage, which was that it would, basically conflict with criminal laws, because not all states allowed people to operate within the bounds of their criminal justice system and still be in same-sex relationships. So the Lawrence versus Texas decision, again, really, I would say, panicked the opponents of same-sex marriage, because it heralded the increasing likelihood that the courts would eventually recognize the right to marry, potentially at the federal level. Knowing this, President at the time, George W. Bush, in 2004, attempted to amend the US Constitution to outright ban gay marriage in the way that the state of Hawaii had already done for their state constitution. But he was blocked in the Senate, and I'm not sure that could have, even if he'd gotten through the Senate, would have made it through enough state legislatures to actually enact that amendment. But he tried in 2004. Since the effort to amend the federal constitution failed, between 2004 and 2006, we saw a number of states amend their constitution at the state level, like Hawaii had done, to outright ban same-sex marriage. Some of those, were later changed or struck down, but some were still standing until the question was finally resolved a little bit later at the federal level. But to continue, by the time we hit 2010, a number of states had caught up to Massachusetts and Vermont, including Connecticut, Iowa. Vermont had changed from civil unions to outright marriage, and New Hampshire. In 2008, in addition, the state of California had struck down its 1977 ban, which was basically framed as marriage is defined as between a woman and a man. But then it was rebanned by Proposition 8 in California by the voters, although there's significant indications that there were some deceptive or fraudulent practices by its proponents and sort of tricking the public about what the bill actually involved. But in any case, based partly on those arguments, but mostly on the content of Proposition 8, the Supreme Court again struck it down and declared it unconstitutional in 2010. So the California Supreme Court was going through this process of, deciding basically same-sex marriage bans can't be tolerated in our state, they're unconstitutional. Still didn't completely codify all rights to marry, but practically speaking, it opened that door. Although the Supreme Court decision in California kept being appealed until 2013. Finally, in 2013, the case Hollingsworth versus Perry legalized same-sex marriage definitively for the state of California. In addition, there were some, one of the things that we've seen is not a lot of support from voters. So, voter-sponsored legislation before 2010 had been mostly negative. If the voters passed something about same-sex marriage, it tended to be against same-sex marriage. So where any progress was being made, it was generally either going to be in the courts or the legislature with a lot of, obviously public mobilization. But in 2010, you start to see majorities of voters in some states amend their constitutions to enable same-sex marriage. And this happened in Maine, in Maryland, in Washington. And again, Maryland was a major landmark because it had been, back in the 1970s, 1973 specifically, the first state to explicitly anticipate and prohibit same-sex marriage. So the fact that the voters amended their constitution to overturn that was a major victory for same-sex marriage advocates, myself included. Massachusetts also found that Section 3 of the Defense of Marriage Act was in conflict with their own constitution, essentially. They felt that it was, by defining marriage in totally heteronormative terms, meaning only a man and a woman, that this was violating their state constitution. This didn't definitively settle anything, but it certainly was a legal shift in the right direction for same-sex marriage and for LGBTQ equality. In the next sort of major landmark that occurred before the final legalization of same-sex marriage by our Supreme Court was a case called US versus Windsor. And the case involved a lesbian couple, Edith Windsor and Thea Spire. They had gotten married in Canada. The state of New York recognized their marriage, but under the Defense of Marriage Act, when one spouse dies, the federal government will not recognize that person as your spouse. And therefore, if you're inheriting from them, you don't get a spousal tax exemption. So things that would just pass from one spouse to another without the government coming in to tax it, was not a protected right for same-sex couples, only for heterosexual couples. In this case, when Edith inherited Thea's estate, she could inherit it, but the federal government showed up to get its taxes because it didn't recognize their marriage and wanted to bill her $363,000 on the assets from their marriage. So Windsor sued in late 2010, and by now, right, George Bush is out of office, and this is the Barack Obama presidency, and our Attorney General is Eric Holder. And they basically were faced with this question, so if Windsor is suing the US government, and in this case, she would be suing the Attorney General, who stands in for the US government when legislation is challenged. They had to decide, would they resist? Would they come to court and argue that Edith should not be able to inherit her partner's estate as a spouse? And they basically said, you know what, we're not going to do it. We're not going to defend the defense. We're not going to defend the Defense of Marriage Act. Hasn't been overturned, but we will not go to court to protect it. So in 2012, the Second Circuit, which is, again, a lower federal court, ruled that one portion of DOMA, specifically Section 3, violated the Equal Protection Clause of the 14th Amendment. So again, this didn't completely eliminate DOMA, but it did address the portion that Edith and Thea were challenging, or rather Edith was challenging on behalf of herself and Thea's estate, which was, basically, can you have federal benefits? So the Supreme Court agreed to hear the case on appeal, and they struck down Section 3 of the Defense of Marriage Act. So again, DOMA wasn't completely gone, and it still allowed people to, at the state level, continue to discriminate. So states didn't have to recognize marriages from other states, but it did take out that element of federal discrimination. So same-sex couples who've been married lawfully in a state could now be recognized by the federal government for, a number of things, including taxation. Finally, the question was decided in June of 2015 in the landmark decision in Obergefell versus Hodges. So this was the tail end of the Obama presidency, and the case emerged actually from multiple groups of plaintiffs in 4 different states: Ohio, Michigan, Kentucky, and Tennessee. Each of these states had a same-sex marriage ban in effect. Each state was refusing to recognize same-sex marriages from other states, which they were still allowed to do under the Defense of Marriage Act. The lead plaintiff, from one of those 4 states, was a man named Jim Obergefell, and he had sued because he was not being allowed to put his name on his late husband's death certificate. So the argument, which basically joined the lawsuits of these multiple plaintiffs against their individual states so that they could be heard by the Supreme Court, was basically all of these laws violate both the equal protection and the due process clauses of the 14th Amendment, meaning basically they are discriminatory and the government is taking away our rights in an arbitrary or unfair way, which is part of what we mean by the lack of due process of law. All of the plaintiffs had won their cases in the trial courts, but when they had appealed in the Sixth Circuit, they had been denied. So the plaintiffs had won at the lower court level, had then lost on appeal, and that had brought the case to the Supreme Court. And the Supreme Court agreed and said 14th Amendment protections, equal protection and due process, can be recognized as applying to same-sex marriage. And in a 5-4 decision, with the majority including Justice Kennedy, who broke ranks from his conservative colleagues, and the progressive justices at the time, Ginsburg, Breyer, Sotomayor, and Kagan, basically indicated that same-sex marriage is protected by the US Constitution. At the time that they did this, same-sex marriage was still outlawed in 13 states. So the decision basically legalized same-sex marriage within those states. One of the things that I want to note about the context about this is that this is an instance where social movement activity, not unusually so, but played a particularly strong role in changing public perception, which pushed the law, which then further pushed public opinion. So there was a 2001 national survey, which was done fairly rigorously, and found that in 2001, 57% of voters opposed same-sex marriage, 57, and 35 supported it. Over the 15-year period from 2001 to 2016, those statistics nearly exactly flipped, meaning by 2016, 55% rather than 35 supported same-sex marriage, and 37% rather than 57 opposed it. So basically the same-sex marriage advocates gained 20%, the opponents to same-sex marriage lost 20. And we saw that reflected in, again, the sort of state level voter decisions, which started to amend constitutions by voter proposition, which was enough to basically help convince the federal courts that it was time to make a change. So before we tie up today, I want to just say a little bit about a few remaining questions. One is just to identify what are the core constitutional questions that have been at the heart of the same-sex marriage same-sex marriage advocacy rather. The first is sexual orientation a basis for invoking equal protection? And again, the decisions kept going both ways, but as public opinion and pressure shifted, state laws started to shift, though some retrenched, and the federal law started to shift. And eventually we reached a point in which the court was ready to say, yes, for the first time, at the level of the Supreme Court, we will change our prior positions, right? We're overruling our 1970s Baker versus Nelson decision, which said there is no major federal question here. And we'll now say that it's now, in accordance with public will and need, it's time to recognize this. The second major constitutional question was, if you deny someone the right to marry, is that enough to constitute discrimination? And that was not hard to argue, because once you recognize that sexual orientation is a protected basis for a discrimination argument, then you can see all the ways that it affects people, like getting a tax bill of over $300,000 or not being able to put your name on your partner's death certificate, or not being able to bring your partner into the United States when you get married. So that was the question still had to be asked, but it wasn't the primary battleground, because there was no real argument that not having the right to marry would have major consequences. And then the last major constitutional question is this a denial of due process? And again, when you've got, sort of state level ban on a whole category, the Supreme Court was ultimately able to say, yeah, there's an issue here. The state is taking away rights from people, essentially by passing bans on who can get married. There were some things that weren't at issue. So for instance, this only relates to marriage as a legal institution performed by legal entities, but it doesn't put any requirement on religious institutions in terms of performing marriages within their own entities. And here, this is significant because religious institutions, which are private, are protected under the First Amendment. So it's a freedom of religion issue. So this only allowed people to assert legal marriage benefits, still protected religious organizations and, in adhering to their own conceptions of what was a legitimate marriage. And that's still true today. There were also a number of ripple effects from the Obergefell decision, and we can definitely say that we've entered a different era in terms of how our legal system relates to LGBTQ communities. One question that people were left with in 2015 is like, okay, right to marry, but does that mean that we're now protected from all sorts of forms of discrimination based on gender identity, as well as sexual orientation? And the Obergefell decision basically had implications for those broader categories, but all it definitively said was that you can't deny someone the right to marry. So it didn't say you can't discriminate in employment. That happened a little later, just last year in June of 2020, in the Bostock versus Clayton decision, which went 6-3, to indicate that we should now understand Title VII of the Civil Rights Act of 1964, which prohibits sex discrimination, to extend to sexual orientation and gender identity. So basically what the Supreme Court was said in June of 2020 is, while it was never true before that the Civil Rights Act of 1964, which does prohibit sex discrimination, was consistently or successfully applied to any arguments about sexual orientation and gender identity, it is now, right? So the meaning of sex discrimination in US civil rights law was changed by the Supreme Court, again, last year, June of 2020. Now, note that this was not a decision that was grounded in a sort of reinterpretation, or at least not a major one, of the Constitution. It was instead basically the court's interpretation of how we should read the Civil Rights Act of 1964. So constitutional thinking certainly came to bear, but this didn't change constitutional definitions in a way that wasn't already true. And that also means that that gain, the application of sex discrimination law to sexual orientation and gender identity, conceivably could be eroded if the Civil Rights Act of 1964 were amended. So Congress could change this, but it's still a significant decision. And again, was in June of 2020 with a fairly conservative court. So Ruth Bader Ginsburg was still with us, but she and her colleagues were still at that point in the minority, 4-5. But the Bostock decision pulled over 2 of the conservative justices, which indicates that even after Justice Ginsburg's death, the Supreme Court would likely rule the same way if the decision went before them today. You never know with today's Supreme Court, but it's at least reasonably arguable. I want to last take note of the Equality Act, or almost last, in thinking about the sort of federal landscape right now. So the Equality Act is a bill which didn't pass yet in the prior session of Congress, unsurprisingly, since the Congress was split with the Senate Republican and the House Democrat, but has been reintroduced in 2021. And if it passes, will extend protection for sexual orientation and gender identity across all relevant civil rights instruments. So not just the Civil Rights Act of 1964. So it would basically be Congress reaffirming and establishing what the Supreme Court did in Bostock. And it has already passed in the 2021 House. And it's stuck now in the Senate as Senate Bill 393. So, and if any of us are paying any attention to our federal governmental landscape, we know right now that the Senate is enormously bogged down. So one of the major concerns that our LGBTQ communities have right now is just, with everything that's immediate and urgent, and with the so tightly split Congress, how many gains that need a lot of attention in the Senate won't be attended to before the next session of Congress, which will begin in January of 2023. So basically, we've got just over a year left for Congress to conceivably, for the Senate to pass the Equality Act. And we know that they're still currently fighting over legislation, which, was front and center in early summer around voting rights and around the social safety net. So for those concerned with kind of the future LGBTQ experiences rights and discrimination, watching what happens with this is time sensitive. A last question that folks tend to ask is, could we swing back? Could our federal legal system ultimately shift to, to reban same-sex marriage, or to otherwise, significantly erode LGBTQ rights? And the simplest answer is yes. A more complicated answer takes more time, but I'll take just a very quick stab at it and say that it's important to understand that there's a major Christian nationalist movement in the United States, which makes up about 2/3 of the people who identify as religious right. So Christian nationalists are not just right-wing Christians. They are right-wing Christians who specifically feel that our legal system and our state should be remade based on their own interpretation of Christian doctrine. And they talk about taking America back for Jesus, and identify a handful of issues, and LGBT rights and same-sex marriage make the top 5 in any given program or platform you see coming out of this movement, as something they need to eradicate and ban. They tackle it on a few different levels. So it's not just about same-sex marriage, it's also about whether information about LGBTQ communities will be included in any positive way in sex education in schools. It's about employment discrimination, housing discrimination, healthcare discrimination. So we have basically a significant movement. And just so folks have a sense, I've never seen a completely exact estimate of how many people are identified as Christian nationalists in the United States, but we know it's a moving target. But what we do know is that somewhere around a little over 1/5 of the US population or approximately 1/5 of the US population are white evangelists. And then if we add white, very conservative Catholics who are anti same-sex rights, then we start to get closer to, around 30%. And then we've got some folks who are not grounding their politics in Christian nationalism, but have other agendas. And we know that people aligned with these movements are particularly inclined to vote. They're very mobilized. They show up for midterms and presidential elections. And if candidates are including rhetoric for or against same-sex marriage in their platforms, it tends to be one of the major variables that will drive their vote, meaning something that these folks identify as a priority. And I want to stress that 70% of the US identifies as Christian, and many of those folks, of course, do not identify as either right-wing or Christian nationalists. But what we are talking about is a large population with, again, estimates somewhere between 30 to 50 million people are some of the statistics I've seen. And so understanding that there's a minority that sizable that's very mobilized and is donating and spending and voting and pushing hard around both issues of abortion and same-sex marriage, and also basically anything that's framed and will have an impact that's anti-Muslim, because Christian nationalists tend to see Islam as sort of the enemy of Christianity. That we can, keep in mind that the answer to that question really depends on the broader landscape of democracy and the extent to which elections and voting will be proportionate to the population. While 30 to 15 million people is a lot, it's not enough to overcome the will of a couple hundred million eligible voters, right? But people have to be able to vote and have to have their vote counted and not suppressed, and have to decide to participate. So all these sort of major urgent issues around the future of democracy, ultimately determine a lot of the answer to this question. If we see strong protections for voting rights, because most of the states which have, a very strong or majority Christian nationalist voting base, or at least one that's right-wing enough to vote with them on these issues, are also the states that are passing restrictive voter laws right now. So in essence, if we see our federal government swing in the direction of a kind of resurgence of Christian nationalist power, then we could easily see some of this be reversed. And for folks who are saying, but did they ever really take power? I want to stress that Mike Pence identifies as a Christian nationalist and is clearly understood by essentially everyone as part of that movement. So having power, if you're in the vice presidency and influencing executive orders and Congress in the way that Pence was doing, we should not preclude the possibility in the near future that that can happen again. So for folks wanting to just delve more into both the social and legal landscape, my book recommendation for today is Sasha Issenberg's The Engagement, America's Quarter-Century Struggle Over Same-Sex Marriage. And again, that's Sasha Issenberg, The Engagement, America's Quarter-Century Struggle Over Same-Sex Marriage. I want to invite folks to join us next month. We will be, and at the end of this month, we'll be back on October 31st on Halloween, and we'll be talking about taxes, talk about boogeymen. So we'll be devoting our episode to taxation. And for those who are like, oh, that sounds really boring, I hate doing my taxes, questions of whether corporations or wealthy people are taxed and the impact for our budget, if they are or are not, are pretty significant and should keep the subject matter interesting to both of you if today's discussion of US versus Windsor and taxation for same-sex married couples didn't already get you there. So taxation next weekend, October 31st at 2 o'clock Pacific, 5 o'clock Eastern time. And then we will return in November. Our schedule should be posted soon. For those who are joining us in Zoom, you'll receive a follow-up link to our event registration page on Eventbrite. For those listening through Spotify, Google, Apple, please like and star us. And you'll also see a link if you want to join one of the live Zoom sessions in the episode description. Thank you so much, everybody, for turning out today, and hope to see you again soon.